Okay. Good evening and welcome to the Holmdel Planning Board meeting of November 28th, 2023. I'd like to roll call, please.
Mr. Aquiliano? Mr. Aquiliano is absent. Mr. Ackerson? Mr. Ackerson is absent. Mr. Emma?
Here.
Mr. Fagan?
Here.
Mr. Castaning?
Here.
Mr. King?
Here.
Ms. LaMountain?
Here.
Ms. Pelosis?
Here.
Mr. Silberman?
Here.
Ms. Polavina? Ms. Polavina is absent. Ms. O'Connor?
Here.
In accordance with the Open Public Meeting Act, New Jersey, SA 10 semicolon 4-10, and the regulations governing remote meetings, NJAC 5 semicolon 34-1.5, I hereby announce that adequate notice and electronic notice of this meeting was provided in a notice dated January 24th, 2023 that was sent to the Asbury Park Press, Two River Times, posted on the bulletin board and on the main access door to Town Hall, filed in the clerk's office, and posted on the township's website, www.holmdeltownship.com. Can we all stand for the Pledge of Allegiance, please? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Can you please remain standing for a moment of silence to honor the military, police, and our first responders, please? Thank you. Okay. First item on the agenda is extension of time. Subash Warrior, 832 Holmdel Road, Block 29, Lot 39, R40B Zone, preliminary final major site plan number 661. Applicant seeks an extension of time for a previously granted approval to subdivide 5.1265 acres into single-family resident lots. Proposed lot 39.01 will have a lot area of 108,991 square feet and will retain an existing single-family residence to be remodeled and garage added. Proposed lot 39.02 will have a lot area of 114,320 square feet, is proposed to be developed with a new single-family home. New lot 39.02 will be a flag lot, requiring a lot frontage variance along Holmdel Road, providing 26.99 feet, 140 feet required. The northerly rear portion of the site contains steep slopes that will place within a conservation easement dedicated to Holmdel. Both homes will share a common driveway located on new lot 39.92. Proof of service, we don't need proof of service. Okay. Hi, how are you?
Good evening, Chairperson and members of the board. My name is Michael Stive. I'm an attorney with offices at 16 Cherry Tree Farm Road in Middletown Township, and I have the privilege of representing the Warriors in connection with this request for extension of approval. This was a final major subdivision approval granted by resolution of this board on November 16th in 2021. It was classified as a major subdivision even though it's only 2 lots, because under your ordinance, if there are more than 500 square feet with 15% or more steep slope, you are classified immediately as a major. So we became a major even though we're only a 2-lot subdivision. Under the municipal land use law, there's a 2-year period on your final approval within which to either A, meet all the conditions of approval, or B, request an extension from the board for a 1-year approval. The board has the authority, the discretion to grant up to 3 1-year approvals. We're here this evening asking for the first 1-year approval with respect to this application.
Well, the board has received your letter for request of extension of time, but if you would please state for the record why you would like this extension.
Yes, there are 2 factors that have resulted in our delay in satisfying all the conditions of approval. The conditions of approval were substantial. I shouldn't say substantial. They were numerous in this case, which isn't unusual in any subdivision application. Because your approvals are conditioned upon the applicant meeting all the technical recommendations of your professionals, your engineer, your planner, and so forth. So there are a list of things that you have to do. In addition to that, the applicant also must pursue and obtain outside approvals from other agencies, such as, in this case, Freehold Soil Conservation District, Monmouth County Planning Board, the New Jersey Department of Environmental Protection. Those things also take time. In addition to that, though that process is normally conducted by the applicant's professional staff, not the attorneys, because the attorneys don't know the technical aspects of this, how to comply with your engineer's comments, your planner's comments. So it normally falls to the engineer, the surveyor, the architect, the planner, in order to process this and coordinate this process. There are two things which have affected the process in this case. First, COVID-19. This approval was in the midst of COVID-19 in 2021, and I think the board can, I don't have to explain to the board that the COVID pandemic wreaked havoc in both the private and public sector. It required people to leave their offices, to reinstate themselves in their homes and remote sites in order to conduct business. It slowed everything down. And that happened both in the private sector, where offices, people were not there anymore. They were working from home. They didn't have all the facilities that they had previously from the office environment. Similarly, the same thing happened in the public sector. Typical example of that, in this case, the applicant required permits from the NJDEP, a designation of flood hazard area and a flood hazard permit, as well as what they call a permit by rule. And that process started right after we received approval in November 2021, and we finally got approvals on October 31st of this year. So there's been that delay due to COVID-19. The second factor that affected this application is that the principal engineer in this matter was Richard Stockton. Unfortunately, Mr. Stockton became ill in 2022 and passed away. His office closed. He was the hub of the wheel, the coordinator for all of the other things that were going on in terms of trying to put together and meet all of the conditions of approval and dot all those I's and cross all of those T's. Unfortunately, he passed away. That left a void in this because the other parties involved that he needed to pull together didn't pull together themselves and caused some delay in things happening. Notwithstanding that we were still prevented from moving forward by NJDEP, waiting for them to get through their approval process. So that having been said, the applicants contacted me early this fall. I looked at the situation and I put that all into the letter that I sent to you, several pages long. We've done a lot of things. There are a lot of things that we've put in. A new stormwater management plan, which has been approved. We've put in a new grading and landscaping plan that's been approved. We've got Freehold Soil Conservation District approval. We finally have our NJDEP approvals. We have a conditional final approval from the county. We've done all of those things. This applicant hasn't sat and waited for things to happen. They've worked very hard at moving forward with these obstacles that they've had to overcome. So that having been said, and without going ad nauseum into the things that are in what I submitted to you in our report as to each condition of approval and where we are in that process, if you'd like, if you have questions, I'll try and address them as best as possible.
Does the board have any other questions?
Otherwise, I would submit to the board that I think the applicant is entitled to an extension of approval for 1 year so we can dot all those I's, cross the T's, and get this across the finish line.
Yeah, they're fairly routinely granted, especially some, in this case it seems with Mr. Stockton, you know, there's more than enough reason, but which is sad, but you know, COVID-19 we can all take notice of too.
Okay. Have a motion?
Yeah,
Board
I'll have a
member would
motion
make-
to approve.
You second?
Second.
Second.
Okay.
And this will run 1 year from the
Did he
date
second?
expired.
Kim?
Just for the record.
Okay. Ms. Mountain?
Yes.
Mr. Fagan?
Yes.
Mr. Castning?
Yes.
Mr. Emma?
Yes.
Mr. King?
Yes.
Ms. Pelosis?
Yes.
Mr. Silverman?
Yes.
Ms. O'Connor?
Yes.
Thank you all very much. We appreciate your time.
Bye.
this evening.
Thank you. Have a good holiday. I'd like to take, if it's okay with Heavenly Estates, I would just like to do another quick extension of time. Item number 4 for Maria Frango's resolution and Olga Lefkefto of 748 Holmdel Road, Block 36, Lot 35.03, number 666. Applicant granted an extension of time for a major subdivision approval memorialization on May 7th, 2023.
Question, were we to have been in attendance on October 17th in order to vote?
Yes.
Yeah.
Yes. So if you want me to tell you who's eligible.
Yes, please.
Kim, Wes, Bill, Tom, and Scott.
Okay.
So anyone can make the motion.
I'll move.
I'll second.
Okay.
Who was second? Bill?
Roll call, please.
Ms. Mountain?
Yes.
Mr. Fagan?
Yes.
Mr. Castaning?
Yes.
Mr. King?
Yes.
And Mr. Silverman?
Yes.
Okay. And at this time, I'd like to send the meeting over to Scott Silverman. He's going to take over. I'm excusing myself from this. Okay, so. Okay,
We have to talk about that first, right?
yes, but
Yep.
you have to, okay, I'm read this. Okay, this stays this way.
So,
Okay, this.
is that me? I don't know what that is.
I'm sorry.
Okay. I'm just gonna move so I can be next to the attorney who helps me in these matters here.
Spread out.
Yeah.
Oh, thanks. Good night, everyone.
Good night. Okay. So I just read this first thing right now, right? Okay. Item number 2, completeness waivers. PB 21663 Heavenly Estates at 26 Main Street, Block 2, Lots 2 and 26, R-4R zone. Preliminary and final major subdivision with associated bulk variances. Applicant seeks a preliminary and final major subdivision to subdivide 2 existing lots, 92.4 acres, into 15 residential lots, 3 open space lots, to be dedicated to the homeowners association, and 1 large lot to remain undeveloped. The property is located along the eastbound side of Newman Springs Road, County Road 520, opposite the Vonage Technology Center, and is within the Rural Conservation District R-4R zone. All right, we just asked what, proof of service now?
Not yet, this is just the completeness one, right? So,
Right.
so it's first is the completeness hearing, so.
Okay.
Good evening, Mr. Chair, members of the board. Salvatore Alfieri on behalf of the applicant. There are 3 submission waivers that we are seeking relief from in order for us to be able to proceed with the public hearing on the actual application. We could have Brian Murphy, our engineer, after he's sworn in, explain the 3 waiver requests and provide the justification for
He
saying.
can just go, we'll swear him in for the hearing, but he
Okay.
doesn't need to.
So Brian, could you summarize for the board the 3 waiver requests from the checklist and the justification for why we either have complied with them or why we need the relief?
Sure. A23 is environmentally sensitive land area map, and D3 is features within 200 feet. That includes ponds, streams, etc. They are provided on the plans. They're shown on the existing conditions plan. I just didn't create a separate plan to show that. I didn't feel the need to create a separate plan labeling that if all that information is provided. So the intent, obviously, is to provide the information which we have So we request a waiver from providing separate sheets of just that information. And lastly is G2, which is cross-sections or profiles of existing and proposed streets, abutting lots and within 200 feet. We do have it for our proposed road, and we do have it for Route 520. The one that we don't have it for is South Holmdel Road. We have no access out onto South Holmdel. We have no impact at all to South Holmdel. So we're just seeking a waiver from that. That's the 3 waivers.
All right, Marty, what do we ask?
Yeah, make sure our engineer doesn't have any concerns.
Okay.
If the board has any concerns, if not, we should have a motion to deem it complete, subject to those waivers.
And of course, if the board during the course of the testimony thinks we need more information to address that, you reserve the right to ask for that.
Correct.
Right. So does anyone on the dais up here have any comments or questions? No?
The motion to deem it complete, subject to those waivers.
Okay.
And subject to, if we need it in the future, we can still ask for it.
Okay, so I feel like a puppet here, but does anyone want to make a motion?
I'll move.
Okay. A second? Tom, you second?
Yeah.
Okay. All right, so roll call, right? Roll call.
Ms. Lamountain?
Yes.
Mr. Fagan?
Yes.
Mr. Castaning?
Yes.
Mr. Emma?
Yes.
Mr. King?
Yes.
Mr. Silverman?
Yes.
Ms. O'Connor?
Yes.
Thank you.
Okay, I'll get the second one. All right. Okay, item number 3, PB 21663, Heavenly Estates, 26 Main Street, Block 2, Lots 2 and 26, 4-4R zone, preliminary and final major subdivision with associated bulk variances. Applicant seeks a preliminary and final major subdivision to subdivide 2 existing lots, 92.4 acres, into 15 residential lots, 3 open space lots, and 1 large lot to remain undeveloped. The property is located along the eastbound side of Newman Springs Road, County Route 520, opposite the Vonage Technology Center, and is within the Rural Conservation District R-4R zone. Okay.
Good evening again, Mr. Chair, members of the board. Salvatore Alfieri on behalf of the applicant. Do you want to take jurisdiction on
Yeah,
it?
first just make sure notice is fine and all the escrows are up to date.
Yes.
Our chairwoman had a appearance of conflict with council, so she's recused herself. Just want to make sure there's no other known conflicts with the applicant or the board members. Seeing none. So just as a housekeeping, Sal, you re-noticed for this hearing, so we're going to treat this hearing as the first hearing.
That's fine.
So all the
It's
prior
just-
testimony, there is reference back to it. Make sure you put testimony on for it. So, because there's new board members that haven't listened to obviously the old.
Yeah, and the only thing we're going to do as it relates to the earlier hearing, which was well over a year ago, is just to summarize briefly what changes have been made, but all the technical issues will be discussed on the current plan, so we agree.
Perfect. Okay. How many witnesses do you think you're going to have tonight?
We have 3 present.
Okay.
We have our engineer, traffic engineer, planner.
Okay. So why don't we swear them in all now? We have to swear in our board professionals too. If everyone would just raise your right hand and stand. You swear to tell the whole truth, nothing but the truth, so help you God.
I do.
For the record, all the witnesses have been sworn, including the board's professionals. And I'll just ask, I know you're sitting in for Bob, but just spell your name, Joe. I don't.
Sure, it's V-E-N-E-Z-I-A.
Thanks.
Joe Amnesia.
There you go. I got the card now.
And we would request that Brian Flannery, I was
There you
with
go.
him last night, Brian Murphy be sworn in.
Okay. No, we just did, so we swore you.
Oh, you swore me?
Sworn in.
So just go through his.
Yeah, so Brian,
Sure.
we're seeking to have you qualified only as a professional engineer tonight, since you're
Correct.
only providing engineering testimony. Would you place your credentials on the record, please?
Sure. I'm a licensed professional engineer in the state of New Jersey. I've been practicing since 1999. I'm a principal at FWH Associates in Toms River. I've been before this board and roughly 100 other boards throughout the state. I've been accepted by the courts as well as a licensed professional engineer. graduate of NJIT with a bachelor's in civil engineering also.
Okay, you may proceed.
Thank you.
I don't mean, right, no one has any issues, right? Okay.
Thank you.
And Brian, are you going to refer to any exhibits that we need to pre-mark?
Yes.
Or we can mark it right
Do we know what we're at?
up. Are we starting at A1?
We should start at A1, yes.
Okay, Brian, so identify, what's today's date?
28.
28. Go ahead, Brian. What would A1 be?
Sure. A1 will be a Google Earth aerial shot of the property.
Mind sticking that on there? Okay, and starting with A1, would you orient the...
Want to do A2 now? Just so we-
Yeah, how many do you have?
Just two.
Okay, sure.
A2 will be a color rendering of sheet 4 of 28, which was submitted to the board.
Here. So, Brian, referring to A1, would you orient the board as to where this property is located and what the surrounding uses are?
Sure, it's block 2. I'm just going to spin this up on its axis because I like north to be up. So the property is indicated in red, roughly in the center of the map. As you can see, it's an existing farm field primarily. We do have a stream. It's the Willow Creek that runs down the west and south side of the property. To the north is Route 520 and the Vonage office building. To the east, we have some commercial uses, and to the west, we have a nursery and also some existing homes along the south and southwest portion of the property on the other side of Willow Creek. The existing use, as we indicated, is a farm. Let's go to the A2. Currently, we are proposing 20 lots total. 15 lots will be new single-family lots. One lot will contain the existing farmhouse, that's the lighter green area, and the farm buildings. And there's 4 open space lots. There's a lot in the center of the circle loop of the roadway. That'll be owned by the HOA. There are 2 open space lots along our frontage up against along 520. Those which also be proposed to be owned by the HOA. There's an additional lot, which is a large, roughly 56-acre lot that wraps around the entire project. It encompasses the Willow Creek as well, and the wetlands and buffers that are part of that. Currently, we're showing that as part of the HOA property. That we've been requested by some of the board professionals to seek the county to take control of that property. We would be willing to do that, but obviously it would be up to the county whether they want it or not, and take control of that. We are proposing a trail. That's the brown line that's running through the property, kind of parallel to the creek. That's within the township master plan. Last time this was approved, I don't know what year it was, 2000.
A while ago.
Yeah, a while ago. It was approved once before this project. But at that point, they sought to have the trail installed, and the DEP would not issue a permit for it. So it seems like the DEP's issue was that it was going to not be a public land. So if that is the issue, and the county is willing to take the land, then hopefully that will resolve that. In the alternative, we would look at possibly either running a 20-foot lot on basically 10 feet on either side of that trail that would be dedicated to the town, or an easement. Again, it depends on what the DEP would allow and permit. So we're kind of at the mercy of DEP as far as the trail goes, but we're willing to install it and try to get the approvals for it. It's just we don't know how the DEP is going to react to the trail, and who's going to own it and what property it's on.
That resolution from the prior approval was for 2012, just for context.
Thank you. We do have a basin, that's the lighter white area at the end of the cul-de-sac in that area. Since we're currently proposing it to be owned by the HOA, we didn't see an issue with that. Obviously, if it's going to be dedicated to the county. The county is not going to want that basin, so we would basically carve that lot out, and it would be an HOA-owned lot because they'll maintain the basin. But we won't know that until we kind of get through it with the county to create that lot. Access is a single access off of 520. We have basically a loop road at the end and a cul-de-sac. All of it's compliant with residential site improvement standards. Sewer and water, we have individual septics for each lot and public water. With regard to the stormwater, we have 9 bioretention basins that would be owned by the HOA. All the roofs will be run into dry wells. Again, that would be owned by the HOA as well for maintenance. And 1 detention basin that I previously mentioned at the end of the cul-de-sac, again, that would be owned by the HOA as well. We discussed the trail, open space, we're over 60%. I'll get into the calculation for that because there was some confusion to make sure that we're clear on that. There's a couple of waivers that are additional waivers that our planner will get into, but I'll just run through the overall, just to mention them. Section 30-5C2, HOA lots shall be between 5 and 8 acres. Lot 2.01, block 201 is greater than 50. That's obviously the one that runs around the outside of the property, so that conforms. Lot 1, which is in the center of the roadway, that green area, that's 1.37 acres. Obviously, it's not really feasible to have a 5-acre lot in the center of the roadway. And then lots 2.03 and 2.19 are the 2 lots that go along the frontage. They're bifurcated by the roadway, so it's not really, and the farm lot, so it's really not feasible to have a 5-acre lot at that location. Sidewalks along 520, none are proposed. There are no sidewalks to connect to going to our west, and as you can see, we have a substantial amount of wetlands and the stream corridor to contend with as well to try to get sidewalk down that area, so we'd look for a waiver from that. Public access and preservation to the areas of the site. Again, if DEP will approve it, we'll gladly provide the public access of the trail. Again, regarding the trails in the master plan, we agree to try to provide and try to get the permits as long as the DEP will issue it. The last waiver is for curb radius. 20 feet is permitted. We're proposing 25, and that's regarding basically the curb radius at the intersections of the internal loop. It just provides better access for school buses and garbage trucks to try to get around the site. It's only an additional 5 feet. It really doesn't impact anything. The county actually requires 35 out at the intersection, which we're providing. So it's really only the internal ones that we're looking at a waiver for to allow 25 feet. Do you have any questions? Or?
Yeah, just you heard me say at the beginning that we were here about a year or so ago. We had a plan for more lots.
Sure.
Can you just summarize what was changed since the initial submission of this application?
Sure. So we added the walkway, the trail walk, as we indicated, that runs through the site. The other item is we lost 2 single-family lots, developable lots. We eliminated those up along the frontage of 520, and we moved basically the development to 300 feet off of 520 currently.
And those 2 lots that we lost, are they the 2 open space lots that currently front on 520?
That's correct.
Okay.
Yes.
And also there's a reference to a letter of interpretation that was obtained from the DEP. That LOI has expired, and,
yep.
And we would have to get a new LOI as a condition of approval if this were approved.
That's correct. Yes.
Okay. Go ahead, you can continue.
I was just going to touch upon some of the review letters and really kind of go into comments that apply to me.
Then before you do that,
sure.
Sorry. Can you describe the lot that has the existing farmhouse, etc.? What's going to be located on that lot if this were approved in the current configuration?
Sure. So right now there's 2 primary residences on the lot. Basically, it was the main house and then basically a house for workers. We would propose to keep that. There's some outbuildings, barns and sheds and so forth that are associated with the farm use that we're proposing to remain. Again, the access is currently off of 520, and we would look to maintain that same access that comes in, and basically the access to all the outbuildings. All that would remain on that property.
So just to clarify, you're proposing to keep all of the buildings?
Yes.
Okay, just making sure. Okay, thanks.
And there is a provision in the ordinance that governs the architectural design of the homes. Again, if this were approved, and we don't have typical homes to show the board, but the applicant would agree as a condition of approval to comply with the architectural standards in the ordinance.
Correct. We're not looking for any variance or waiver from the architectural standards.
And there's also a provision in the ordinance for payments to the town for the affordable housing obligation, and as a condition of approval and as part of the developer's agreement, the applicant would agree to comply with that as well.
Certainly.
Okay, fine. Now, the rest all relate to the report, so go ahead.
The Environmental Commission letter dated 11/15/23 kind of really speaks to the trail again, and I kind of discussed that already, that we would seek to get the county to accept that lot that the trail is on, and obviously the trail as well. Provided that they do agree to that, obviously we would be happy to do so. And again, I think if we did do that, we'd have to carve out the basin lot to be maintained by the HOA, and the remainder would go to the town, or to the county rather. The Collier's letter dated 11/21/23. The only items I really had on that one were on page 10, item 3.9, 1. The ordinance supersedes is superseded by RSI, as we have sidewalk on one side of the roadway. Also, the master plan also, figure 5 also references sidewalk on one side of the road, so we're compliant with the master plan as well. Page 11, item 310. Just wondering why we submitted 5 names when we only have 2 roads. Or usually you don't get all the names approved that you hope, so we typically provide more names than we need, hoping that we get 2 out of the 5 approved. Page 13, item 8.2. I would request not to provide the electrical, gas, and cable on the plan, those lines, only because we don't have any control over that. Those utilities do their own layout, so I can show it, but it's really meaningless. They're not going to follow what I do. I've tried it before, they don't. And so I would ask that we not do that. Page 14, item 10.2, we kind of discussed the architectural plans already. Page 14, item 11.2, this is regarding the Soil Conservation District. There's a violation on the property currently. We're into the Soil Conservation District for an approval. Once we have that approval, obviously we'll provide that to the board professionals and the board.
And before you move off the Collier report,
Sure.
To the extent you haven't commented on any of the provisions in that report, we would agree as a condition of approval to address them all to the satisfaction of the engineer?
Yes.
And that includes the stormwater management comments, the landscaping, the lighting, et cetera?
Absolutely.
Okay, sorry, continue.
Sure. The Philip Price letter of 11/22/23. Again, most of this is planning testimony, so I'm just going to kind of touch on the items that kind of apply to me, I guess. Page 4, item A4, is regarding the other dwelling that's on the farm lot. Again, that would be proposed to remain, and it would be basically utilized for the farm use as it is currently. Page 4, item B6, with regard to the open space, we had indicated that we have 60.9 acres of open space, which is roughly 65.8% of the site. And just to run through how we got to that, so lot 1, which is the lot in the middle of the cul-de-sac, is 1.378 acres. Lot 2.03, which is near the entrance of the project along 520, is 2.105 acres. Lot 2.19, which is also on the other side of the entrance, is 1.859 acres. Lot 2.01, which is the larger lot that wraps around the site, is 56.894 acres. Then we took 1.3 acres off of that lot for the basin area, because that basin doesn't count as open space. So we remove that, and that comes out to the 60.9 that we're representing. So they just asked that we basically put on the record how we got to the 60.9. Page 4, item C7. We're not seeking any relief on the architectural design, as we indicated. Page 5, item E13. The area preservation and reservation are shown and noted on sheet 4 of the plans, and you know, they're basically delineated on that plan. With regard to the inter-department letter of 11/13/23, we agree with the items in the Director of Infrastructure, the fire official, and the traffic. The construction official basically, you know, was regarding the soils that I already discussed, that we're going for the soils permit from the Soil Conservation District.
I wanted to focus on two of the areas of relief, so that from an engineering point of view, you could explain to the board what they consist of.
Sure.
The first relates to the fact that the ordinance requires 500 feet of buffer along the current roadway. Is that correct?
Well, you're referring to the master plan map. So,
I'm sorry, the master plan.
So,
yes.
there's no delineated distance. It's kind of
you estimated from the diagram that's
Yeah.
attached to the master plan
correct.
that it's approximately 500 feet.
Approximately.
And we're proposing 300.
300.
Okay.
Yes.
And then the other is the preservation areas. Can you show the board on the plan A2 where those preservation areas are, and then explain what the relief is that would be required?
So the rural preservation areas are hatched with dots. It's a little hard to see from your distance, but it's basically the area that runs along the east side of the property, and then the south, and then it wraps up again along the west. The preservation area is the hatched, the solid striping that we're showing on the plan. That basically goes into the preservation area. Again, it's along that area by the basin, the center of the lot, of the cul-de-sac rather, and then just to the west of the farm lot and along both sides of our entrance. So those lots basically cut. There's a 300-foot buffer that also comes onto each one of these lots along the east side of the property, and it just touches the back of the lots along the west side of the property and onto the farm lot. So basically, we'd have to compress the site and push it up into the farm lot in order to you know, move those lots out of that area.
And so there are areas within the 300-foot stream corridor buffer that are located to the rear of some of the proposed lots. Is that
That's correct.
And those areas are going to be preserved in a conservation easement, so they can't be disturbed.
That's correct.
So whether they're a separate lot or on the homeowners' lots, they still have the same protection.
That's correct.
And would the applicant agree if the board requested it to have some form of demarcation on the boundary so that the residents know where that
Some visual, sure.
area begins?
Yes.
And then lastly, you talked about some of the outside agency approvals that are required. Of course, we indicated the LOI from the NJDEP. Route 520 is a county road, so we still have to get Monmouth County Planning Board approval, and as part of that, we would go to the Parks Department to determine if they would take the open space lot.
That's correct.
What other outside agency approvals are required?
We'll have both water and sewer approvals, local, county, and also at the state level for water, rather. We're going to have a discharge permit for the stormwater basin for flood hazard and for wetlands. And we'll have a flood hazard delineation that expired also, so we're going to have to basically just reapply for that flood hazard designation.
And those applications, assuming the board would approve this application, would then be filed in order to perfect this approval?
That's correct.
That's all the engineering testimony we have, Mr. Chair.
Yeah, Joe, Joe or Kate, do you have anything to say in response?
Well, I'm just going to give a brief rundown of this application for some of the newer sorry, who when I gave a similar rundown, sorry Joe, that's not normally how I treat my engineers here. So as some of you probably noticed, this report is very much longer and more detailed than the ones our office typically does, where we try to just get to the point. The zone that this property is in, the R4R Rural Conservation District, is kind of a unique zone to Holmdel. It's a type of, it's called form-based zoning, where it's less, kind of looking at the individual lots, it's really looking at kind of the form of this portion of the township, and putting in a district in place here that was meant to really regulate the scale of development here while preserving all of the environmental constraints in this area. So this was done at approximately 2005, amended a few times after that till about 2007-8. And there's a master plan amendment that was done at that time that set forth kind of all of these regulations, which were then incorporated into the zoning. If you notice at the end of my report, there were a few maps. Those are the quote unquote master plan maps that are referenced therein. And the idea is that, not having, that in order to have a development that, had the visual impact that was anticipated by this zone, et cetera, that it would match these maps significantly, but it doesn't have to be exact. So that's, what Mr. Murphy was just talking about with like the 500-foot setback, et cetera, from 520. That isn't, there's no number shown on the plans, but it's generally shown to, kind of be equivalent to like one of the adjacent property lines, et cetera. So one thing that's changed in the interim since this master plan amendment and the zoning was originally adopted is that this portion of the Willow Brook in the rear of the property was elevated to a Category 1 stream, which requires 300-foot buffer. I believe at the time of the master plan amendment, it either required 100 foot or 150 feet. So that's really the reason why this site had, they've had to lose. One of the reasons we asked them to cut back on the number of lots was because in their prior submission, the lots were much closer to 520 in order to have the number of lots permitted by the density, but still respecting that DEP stream corridor. So, so the applicant, does have, you might want to call it a little bit of a hardship. I'll let their planner talk about that. But, there has been a change to the site in that sense. Some of the other things that are mentioned in here in my report and that the engineer alluded to, things like preservation areas, reservation areas, and specific street typologies, those are all really right for this zone in particular. And the preservation area is supposed to be kind of the equivalent of a conservation easement, but it's meant to be kind of more of the space that's not on the property. That's why I asked for, those calculations about like, how did they get to the open space? Because we wanted to make sure that that none of the, that the stormwater facilities were included, and B, that none of the conservation easement areas that happen to cross over onto private property, or what would be private property, of the individual lots were included, because those are both specifically not counted as such per the ordinance. So, I'm fine with all the, the information that the applicant has given on that tonight. And I have to admit that I might need to look a little further into this, because with regards to the other lot, if that would remain the farmhouse, there would be a secondary dwelling on that. The township does permit things like secondary farmhouse dwellings. So that is, and the idea was always to retain the original house to the best of everyone's ability on that lot. The other thing that I would note for the applicant is that one of the other quirks of this ordinance is that the cluster development standards, which are in the township ordinance at 30-55, which typically apply to R40A, R40B, R4, those are not applicable here. So some of those waivers you mentioned are not specifically needed, like the things about dedicating lot sizes to the homeowners association, et cetera. Like, because for this property, for example, that lot next to the roadway, even with the 500-foot setback or whatever, it was never going to be 8 acres. So some of those are not going to be necessary. But everything, I think that between our report and the Collier's report, we pretty much covered most of the details of this complex, unique zoning district. If anybody has any other questions about that, I'd be happy, just for your context as far as listening to the rest of the testimony, just because it is a slightly different sort of situation than you're typically looking at, where it's just like, oh, they didn't meet the 50-foot setback variance. They didn't meet the 300-foot buffer or 100-foot buffer variance. It's more of like it's more of a holistic approach to zoning that is what's here, and that's why those maps are attached. So, but I would thank the applicant for their testimony. I think that was very helpful. And I would also note that, yes, number E13 in my report was supposed to be crossed out. The applicant did provide the preservation and reservation areas. And the rest, I'll wait for their planner, unless anyone has any specific questions.
So I think it's Murphy, Mr. Murphy,
Yes.
right? So you only had an issue on a few of Philip's comments, right?
Correct. There's
Right.
going to be more planning testimony.
Yeah, he was mostly clarifying, I would
Yeah,
say, rather than, I'm not saying that they couldn't meet them, just either answering questions or clarifying.
Right, so what I'm saying is, based on what he said, you're pretty much satisfied if he's taking care of everything here, that your concerns are satisfied.
As of now,
Yeah.
we always reserve the right as more
Right.
things come up. I think that, I was going to ask, what the status of everything with the county was, because I know that the county, may be interested in taking that, which would kind of change a lot of the, I think it would make things easier, honestly, is because a lot of this stuff with who's going to have an HOA, but it sounds like the applicant has been working on that, so.
Okay. Joe, you got something to add?
In terms of areas of overlap between our reports, engineering, and planning, I think the lights have been addressed in terms of being downward facing. Is that your testimony?
Yes.
There's no dark.
Yeah,
sides?
correct. They're focused down.
Okay. And I think we'll get into this a little more with our planner, but in terms of some of the differences between the RSIS requirements and the ordinance, in terms of issuing de minimis exemptions, for exceptions from that, I think we're on the right path towards being able to do that.
Maybe we should, I know you addressed RSIS a couple times. Are there any, because again, one of the things with this ordinance is that it, stated that sometimes what they're looking for with streets, sidewalks, et cetera, what the township's looking for with this ordinance doesn't comport directly with RSIS, but RSIS does technically override that. Are there any of those specific items that you noticed where the board, where you're either asking for an exception or they think the board may have a question on something?
Yeah, we don't need any exceptions. The only comment that really kind of came into play with RSIS is the sidewalks on two sides of the street. The ordinance requires two sides. The master plan overlay only wants one side, and RSIS only requires one side.
Yes.
So that's what. So we comply with the master plan, and again, that kind of overrides, as your plan has indicated, it's a special zone in town.
Okay, yeah,
So
this is item D11 in my report, which kind of succinctly describes, there is a discrepancy between the ordinance and the roadway, and the map. So if that's up to the board, if the board is comfortable with sidewalks on one side, basically.
Yeah.
We're talking about the sidewalks in the loop, not along 520.
That's correct, internal.
Sure.
The preservation area, as defined in the ordinance, specifically section 3-212910A, says that it must include riparian corridors and stream buffers. So is the C1 buffer considered a stream buffer?
So yes, it is. I'll let you finish if you have a second.
Yeah,
We'll go.
so,
Yeah.
and therefore the ordinance also kind of states that no building lots shall have a buffer crossing onto their property. And when I look at the plan, there are 9 lots, including the larger lot, the existing farmhouse lot, that have the buffer within their boundaries. So there's an inconsistency here. And I think it's inappropriate to assume that this application with the 15 lots conforms to the preservation part of the ordinance.
So I can, just as an answer to that, because I did, or just, kind of my thoughts on that, are that I saw that in the HEC's letter. So there's a couple of things here. One is that, yes, when you read the preservation area ordinance, like a variance may technically be required for that, because of the fact that some of the, it's so sort of like it's kind of like a cycle where it's like the ordinance requires that all stream buffers be located in a preservation area, and then states that all preservation areas may not be on the individual building lots. So they're either looking for, I would say maybe the variance might be kind of, or the waiver would be to have some of the stream corridors outside of the preservation area, or to have preservation areas on a building lot. The other thing is, and this is what I was kind of alluding to before with the open space calculations, the applicant has not included those conservation areas on those lots as part of their overall open space calculation. So even though, and I think that when the original ordinance was written, it, again, the stream corridors were smaller, but it was basically to ensure that you weren't trying to double dip with having a preservation area on a building lot and then also counting it as open space for the major thing.
I'm fine with what your latter point here. What disturbs me, though, is that 12 of the lots have the riparian buffer, stream buffer, crossing them, and in the ordinance, the preservation component doesn't allow that. And then you talked about a variance being required, and it's a significant variance if you're talking 12 lots. It's not just one lot or two lots, and it certainly isn't a waiver.
Yes, and the applicant has agreed to put them in a conservation easement, which is required by ordinance, by the main township ordinance, but that is not technically the letter of this R4R ordinance.
A buffer is just that, a buffer. If the buffer is dissecting those lots that we're talking about on the east and west side of the application, it's not a buffer then, right? A little sign in the middle of the backyard lawn is not a buffer.
Well, I understand your point. I just want to clarify that in any other zone in Holmdel Township that would be permitted.
But
many of the conservation easements throughout the township are stream buffers.
And we feel it is a buffer. It's going to be preserved in a conservation easement. The issue isn't whether it's a buffer. The issue is whether it's on the building lot or not. But the function is the same.
Right. And the letter of this ordinance differentiates between that in a way that is not meant to apply to this property in particular. So yes, it's worth raising.
So just again, this is getting down in the weeds, no pun intended, but it is against the ordinance as it's written currently, having that buffer dissecting building lots.
Having the preservation area, which was to include all stream buffers, was not intended to be on all building. Was not intended to cross over onto building lots.
Thank you.
In the R4R zone.
I have another question. Regarding the 500-foot buffer on the frontage of 520, the master plan ordinance is 500 feet or it isn't 500 feet?
The master plan, I will read it to you, and I'll point you to the item in my letter that states it. Please hold. It's towards the beginning. Let's see.
Per the master plan, the building
We're
lots...
looking at
A2.
A2.
Yeah.
Per the master, so per 129.3C, permitted building types shall be constructed in locations shown in the master plan, though these locations shall be considered approximate and subject to reasonable modifications for site-specific factors when development applications are submitted.
So it comes down to, is 300 feet approximately 500 feet? That's really the question, isn't it?
And that is, that's up to the board. And honestly, the way that this is written, I think it's up to the board to determine if you're going to, I think we've asked the applicant to treat that as a variance, even though it's not to the letter of 500 feet versus 300 feet. But that's up to the board to, if they want to grant, if they think it rises to the level of a variance, and then two, if they want to grant a variance for it, in my opinion.
I sympathize with these two as well. I have some concerns about the exact same thing. First, about the buffers, when we talk about 300 feet, is that 150 foot to each side of the stream, or is it 300?
300 on either side.
Either so, total 600 for the whole, right?
Yes,
On
and
both
that's
sides.
set by NJDEP.
So I would also talk about no conservation zones on the property, but specifically, when we talk about coverage, I think the coverage allowed is 25% in this area. We're talking about like impervious surface, right? That's what coverage would be considered.
Where is that? Let's see.
I thought in one of the plans you had, it may be at that chart right at the top there. I can't see that far though.
Yeah, it has an individual lot coverage.
Oh, yes.
25%.
For this
Yeah.
certain building
And
type.
showing that
yes.
the building is less than 25%. So if the conservation area was allowed onto the property, does that portion still go to the whole property of the individual house? In other words, you look at the whole lot, and then that conservation area counts as open, right?
Yes, that's the way township ordinance treats that in general, and it's not different here.
Okay. It seems that we're going to be talking a lot about water, how to get rid of the water from rains, from storms, and things like that. And it looks like there's at least 3 different methods of controlling the water. One would be a detention basin.
Yeah, infiltration basin at the end of the...
Okay. I just want to get for future our terminology right. So
Sure.
so you're calling it a retention basin.
Technically an infiltration basin. It does have a discharge.
Okay.
But it recharges basically the water quality storm, and then there's a discharge pipe that would go out from the basin for larger storms.
Yeah, the majority of retention basins or basins I see are dry, but like one on Laurel Avenue where Best Buy is, that's always wet.
Mhm.
How is this one going to be?
Dry.
Okay.
Dry basin.
Then we have rain gardens,
Yes.
and there's a total of 9,
9.
I thought.
Yeah.
Okay. And then finally, they're managing the runoff from the roofs of the house. What are we calling that?
Those are dry wells.
Okay. At some point, you mentioned, I thought you said the dry wells were owned by HOA, but that's not true, right?
It is now. The DEP requirements are that dry wells have to be maintained by an HOA, not an individual homeowner.
We're talking about what's shown on the plan. Dry well is right at the back of the house, right? It's where
Correct.
the gutters run
The
to.
gutters run to them, yeah.
And this is a new phenomenon, right?
Yeah, it's new. It used to be each individual owner was responsible for their dry well. It's not that anymore. The DEP regulations require that the HOA, even if let's say the town was taking all the other drainage, we would have to create an HOA for the dry wells. Yeah.
So let me just reiterate what you just said. Even if this were a straight development, no basins required at all, where my gutters run to the back of my house into a dry well, they would have to create a homeowners association to maintain those dry wells.
That is correct, under the current regulations.
So the 3 things we're talking about are I'm going to call it a detention basin, rain gardens, and dry wells. Those are the main 3, or the only 3 things that control water,
Correct.
right? Okay, that's it. Thank you.
Sure.
Yeah, good, Bill.
To the farm lot, which is now, was originally 9 acres, I believe. It's now, whatever it is, not even 5. Therefore, it's not farm qualifiable, right,
For tax purposes.
for tax purposes. I mean, obviously, you can farm it.
Sure.
But I think having a secondary residence on, that's intended to be a house for farm workers on a piece of property that really is not a farm anymore shouldn't be allowed.
That's exactly what I was mentioning when I said that when they mentioned they were going to keep the second dwelling. I'm not sure if that would technically be permitted because that is a farm for tax purposes, but also much of the township's ordinances are you have to be farm qualified. You have to qualify for farm qualification in order to also qualify for township farm protections. So I think that a variance might be in.
Yeah, either a variance or the structure should be removed.
Yes.
And Sal might remember that we, way back when, we asked that the existing barn there be looked at by a historical individual from the county, and the next thing we know, and Sal indicated that would take place, and then we found out the barn had been torn down, and it was a historical structure. So that was an annoyance.
Oh, that's interesting. I didn't know that. I got one question, just from my own knowledge. What's the purpose of the 500-foot offset from 520? Why is it 500 versus 400 versus 300? Is there?
Do you see are you looking at the map at the end of my? I think it's really meant to just keep the visual buffer that was in place there. I'm going to put you to my report map. Useful one would probably be figure 2 towards the end. The idea was, and this one unfortunately doesn't have the existing home shown on it, but you can kind of see that it aligns with some of like it would keep that farm vista in that location. And if I may also quote the master plan. Goals were to essentially regulate building construction according to their type, the nature, and extent of their use. The amendment includes a building type map, which is figure 2, that indicates the permitted locations of various building types in southwestern Holmdel. Holmdel seeks to utilize building regulations here to promote good civic design and arrangement, to provide for a desirable visual and character, and to respect the historic character of Holmdel Village. So the idea was, but in short, the idea was that you would keep the farm vista from 520 in that location.
So
Just for the record, Kate, you're referring to this, when you say figure 2, the second dot?
Yes, figure 2 which is an appendix to my report, but which is from the 2005 master plan amendment, which is what I was just quoting
That's your
from.
second map that's attached?
That's the second map that's
Page
attached,
7.
yes. I believe it should be lower left-hand corner.
Page 7.
Hey, Kate, just clarification, this map was done before the C1 stream corridor?
Yes, all of the
So-
master plan amendment and the zoning amendments
So
were all
the
done.
proposed improvements to the rear of this lot have to get pushed forward. We lose that area too because of the C1, where the cul-de-sac extends all the way back.
You know what, because it wasn't updated, I can't really say that, but I think that's the argument for your planner. But yes, and I have to admit that I haven't measured what the distance is on that map from the last lot to the back of the property, but it was intended to reflect the current environmental conditions at that time, which was 2005.
I have another question. What's the sole purpose of the bulb at the end of the roads there?
Basically provide fire truck turnaround once we have access down to the basin and access to the last 2 lots as well.
Yeah, I would argue that the justification was for the 2 lots. I'm sure the fire truck could navigate around that island, and certainly an access to the infiltration pond could be created without the bow. So I think the main reason there is you wanted 2 more lots.
And we're still well under the density that's permitted.
Okay, good, Ron.
Can you put A1 back up? I'm referring to the Collier's letter, page 14 of 15, 11.2 of the stop construction order. It came up in a town council meeting last year, I think it was, on the southernmost end of the property. I guess that would be south of the retention basin. There was illegal dumping there. Is that what that stop construction order references, the illegal dumping on the most southern part of the plot? There was some illegal dumping that was brought up in a town council meeting.
Okay. Yeah, it was basically soil material that was brought into the site, and that's what they're referring to.
But it was illegal dump, correct? And that's part of the plot.
Yeah, there was no soil permit. Yeah, so we're in for soil permit now.
So wetlands was filled and the soil was not tested, it was just dumped there, correct?
Wetlands was not filled. It was outside of the wetland area.
But the soil was not tested, it was just brought in.
I believe they do have soil results, is my understanding.
It's my understanding that the soil was not tested.
Do you have those test results that can be
We can
provided?
provide whatever we have to the board professionals on the board, sure.
Yeah, I would note that he's not here tonight, but the construction official's letter does say that he has not seen those reports.
Sure.
Okay. Tom?
I have a question regarding the rain gardens.
Yes, sir.
Are they to drain the downspouts or the roadway water?
No, it's more roadway and yard area. So it's the front yard areas that are coming out and part of the roadway.
How does the roadway water get to the...
So the new DEP way, the old way we had the inlets, storm pipe, and a detention basin somewhere on the site that everything drained to. So we can't do that any longer. Now they want all little smaller pockets of small treatment and recharge. So that's where the rain gardens come into place. That's why there's 9 of them. So they're spread out along the roadway, parallel to the roads. And there's a small, basically, inlet that directs with a small pipe that directs it into the rain gardens. And then once they fill, then there's an outlet that spills back into the gutter of the roadway and goes down to the next one and the next one and so forth. Kind of daisy chain down the roadway to clean the water. That's the idea is that it'll be cleaning the water through these rain gardens.
Very good, thank you.
And there's landscaping there, right?
Yeah, there's all landscape requirements that DEP has for the rain gardens and what plants can and can't go in there, and we have to follow all that.
So they're like aesthetically pleasing. They're not just...
They're okay.
I actually Googled it because I wanted to see, and the ones I'm seeing are really cool.
Yeah, some of them are nice. Some of them are nice. It's all in the eye of the beholder.
Okay,
Keep going.
Wes, do you have more questions?
Sure.
All right.
There's a note of a foxhole, and what's a
Yes.
foxhole?
So that's also a method of getting the water underneath the sidewalk. So it's shallow, so the water can run off the gutter. The foxhole is just it's the manufacturer's name for it. So it's basically a slot that can run underneath the sidewalk, so you don't have a hump in the sidewalk or a dip in the sidewalk, and it runs from the gutter under the sidewalk and into these rain gardens. They're pretty regularly used right now. I'll be honest with you, before we started rain gardens and everything else, we'd never use those, but now they're pretty much used as a standard now to get them into the rain gardens.
Would the right word be a swale for a different kind of structure that might be, for example, if I were purchasing one of these homes, I might not choose to have a rain garden in my property. So
Won't be their choice.
Does a swale accomplish, or is that allowed? Is it a similar thing? Whereby, what I'm saying is you're spreading out that among the properties, typically along the sidewalk, along the road where it's a dip.
Yeah, it's to the naked eye when you're driving, it looks like a ditch. But the reality is there's requirements on how the rain garden is constructed, the material that's below the rain garden, and the plantings that are in the rain garden as well. So all three of those things go into what makes that a difference between a ditch and a rain garden.
And lastly, when we talk about the dry wells, they're all located off the back, mostly off the back of every home.
Correct.
I don't see the distance, but is anything allowed to be constructed over that?
No.
Okay.
No.
So.
I mean, you could put a patio or something over it, but.
Oh, you can.
Yeah, sure.
A deck.
Yeah, sure.
Patio.
You'd need access to the ports. Is the only thing you need.
Okay. Thank you.
And obviously, you're running the risk if you have to replace or do something to it. You're tearing apart whatever you put on top of it.
All right, anyone else have any questions? I think we have another witness, right, Martin?
Yeah, we're going to call our traffic engineer.
Okay.
Thanks.
Do you have to give us qualifications? Yeah, so, sir, before you start, just give us your name and a little bit of your background.
Yes, sir. John Ray, REA. I'm a principal with McDonough and Ray Associates. We're a traffic engineering firm, a local Monmouth County traffic engineering firm located in Manasquan, New Jersey. Got a total of, I got to add it up now, 49 years experience in the traffic engineering field. The last 39 years I've been doing consulting work here in the state of New Jersey. I'm a licensed professional engineer in the state of New Jersey. Educationally, I have an undergraduate degree in civil engineering from NJIT, which I obtained in 1974. And I also have a master's degree in transportation engineering from NYU, which I obtained in 1978. And I've testified before this board, and unfortunately, probably at last count, over 260 boards across the state. Within CE.
Okay. All right, you may proceed on that. I don't
Thank
think
you.
anyone has any objections, right? So.
Okay, John, your office prepared a traffic analysis for this newest design, and can you describe for the board
Sure.
what you did to create that report that you prepared and what the results of the report were?
Sure. Well, we collected traffic counts at the access, the proposed access, which is opposite the Vonage Technology Park. We expanded those traffic counts, those traffic volumes to a design year of 2027, which is approximately the year when we would hope that with the approvals and the real estate market being what it is, that the homes would be constructed and occupied. In projecting those traffic volumes to a design year of 2027, we assumed full occupancy of the Vonage Technology Park because we know it's not fully occupied right now. So we went into the Institute of Transportation Engineers trip generation manual, and we took the entire technology park of 400,000 square feet. We assumed it was fully occupied. And also, in order to do a conservative analysis, we looked at the NJDOT's background traffic growth rate data for Newman Springs Road. And even though they were projecting 1% growth from now until 2027, we doubled the growth rate. We wanted to do a conservative analysis. And our findings were that the exiting movements from our driveway connection to Newman Springs Road will do so at what we call acceptable levels of service. And I can actually give you the delays that the highway capacity manual models. In the morning, during the morning peak hour, the average delay for people entering Newman Springs Road will be 28 seconds. And during the afternoon peak hour, 18 seconds. And those are within acceptable traffic engineering parameters. We've also met with Monmouth County. We had a DRC, a Development Review Committee meeting. The county would like us to stripe a westbound left turn lane opposite the existing left turn lane that goes into the Vonage Technology Park. We will have to do that in order to obtain our county approval. We also have to provide site triangle easements along Route 520 to ensure that The sight distance east and west along Newman Springs Road meets the county and acceptable standards. And so on balance, I mean, usually the types of studies that I'm involved in and I have to do, this is a relatively small study. I think we have, 15 new lots now? When we originally did the traffic study, we assumed 17 lots. We've lost 2 lots. It's a conservative study, and what it shows is that there will be capacity for our traffic to get out onto Newman Springs Road during that morning and afternoon peak hour period, even in consideration of full occupancy of the Vonage Technology Park, and like I said, doubling the growth rate to just make sure we did a conservative analysis. And I know Brian Murphy talked about the RSIS. The subdivision plan itself has been designed in accordance with the RSIS. I can tell you that. And that basically summarizes it.
Now, also, we received the interdepartmental review, which was conducted by the traffic safety officer.
Yes.
And have you had an opportunity to review that?
Yes, I have, and we can comply with the 1, 2, 3, 4 items that he suggested.
Okay, and they're consistent with some of what the county's requiring too.
Correct.
Right?
Yes.
All right, and of course, Monmouth County Planning Board has jurisdiction over Route 520?
Yes, and like I said, we've had what you would call a pre-application or DRC meeting with them. They've told us basically what they're looking for, and we will provide it.
That's all we have for traffic, Mr. Chair.
Okay, Joe, Kate, you have anything to say, or any questions or comments on the traffic? Ladies and gentlemen of the board, does anyone else have any questions or comments?
The worst case is a D.
Yes.
And that's one level up from an F, which is a failing grade, correct?
2 levels from F.
2 levels.
D and E and F. And generally speaking, anything operating at level of service E or better is considered to be acceptable. So yes, it's not an F. It's pretty far from being an F. Let me give you some numbers. We're projecting 28 seconds of delay for the morning peak hour. I just want to make sure everything is understood fully. You have to have over 50 seconds of delay in order to get into F. So we're quite a ways from F.
The exit from Vonage and the exit from this property, they're not, well, from Vonage, is that just a right or a left? Is that, it's sort of...
You can make either movement from the Vonage.
Well, let's look at the left for a minute. If I'm making a left, I have to go out straight and then make a left. It's not that curved road. The curved road is to gain entry in.
Yeah, let me see if I can get the proper map up. Okay. I think this is A2.
Okay, if I'm coming out of Vonage, I want to make a left and
Correct.
come out to the intersection, enter that intersection, make a left.
Correct.
Are those streets directly across from one another?
Yes.
And then, if I'm coming out of the new development, I can make a left. This is not a double yellow line, or is it?
There will be a double yellow center line there. That's one of the things that the police have asked us to do for the first certain section of our driveway connection to Newman Springs Road. But it'll be a single lane from which you can make either a left or a right turn.
Let's do that again. Coming out of this development.
Yes.
Going out. Obviously, there's one coming in.
Correct.
Going out. One lane or two lanes?
One lane. One lane going out, one lane coming in.
Okay, so going out, from that lane, I can make, obviously, right, but I can also make a left?
Correct.
Legal.
Yes. Yes, it is legal, and the county has looked at this, and they're going to permit left and right turns. We don't want people making only right turns and then making an illegal U-turn somewhere to get back to the west.
But you're adding on 520 a left-hand turning lane.
Yes.
In both directions.
There already is one going into Vonage. We're going to provide what we would call a mirror image of the Vonage left turn lane in the opposite direction. It'll be a head-to-head lined up left turn lane. Yes. Okay.
We good? Bill, you look like you're itching. No? All right. All right, Counselor, do you have a third witness?
Yes, but can we take a break before we call the third
Sure,
witness?
sure. We can take a, I'm a judge. We'll take a 5-minute recess?
Perfect.
All right.
Thank you.
There you go. There you go. Boom, boom, boom. All right.
Yeah, there should be.
Oh, there we go. All right, we're calling back to order.
You blew that sign off.
Yeah, see, it's my voice, it carries. I guess at this time, we're gonna open it up to public questions to the two professionals that testified regarding the traffic and the site, if anyone has anything to ask. Okay, since we have none, I guess I'll close that portion up.
So, Mr. Chair, we would like, we heard some of the concerns, and I don't know if we could address them, but we want to have an opportunity to regroup and discuss that with our professionals and see if we could address some of the comments we've received tonight. The only witness we have left is the planner, and we would prefer not putting him on tonight, because if we do make any changes, it will change his testimony, and we'd have to do it all over again. So we're going to ask that we be carried to the next available meeting that we could coordinate tonight, and then we'd, of course, grant the board any extension that would be required.
And you would have your engineer back as well.
Mr. Flanner, Mr. Murphy will be back at the next hearing. We're not going to bring Mr. Ray back unless the board members require it, and then our planner, of course, would be here.
Yeah.
Procedural issue. If they come back in December, that's okay, because we'll all be here. If they come back in the new year, some of us will have been replaced or may be here, who knows? So how does that work?
They'll have to, anybody that's new would have to listen to the tapes and sign that affidavit. So that does happen, obviously, every year. Right, it could happen.
Yeah, that's why I had to sign that paper last meeting for the other one. So,
Right.
Yeah.
And I can't come back in December. I'm booked the rest of the year, unfortunately, so whenever, I don't know when your next available meeting is. You have a reorg? Do you carry it, do you carry it to the
We would
reorg?
carry to the reorg, so we know when the
Okay.
official calendar is, and then we'd carry it again to the new
Okay.
meeting date.
That's fine. That's fine.
Well, we know what reorg is, right? So
So it should be on, oh no, here. That's the 9th, sorry, January 9th.
So we would request that the application be carried to the January 9th meeting without further notice, at which time a new date would be set for the actual public hearing.
okay, do I have to make a motion for that or no? We just accept it,
No, we
right?
just accept it.
Okay, yeah, I guess we don't have no problems with that.
And we request, Marty, that you could state that on the record, so if anybody's here, they know that they're not going to get a new notice.
In case if there's members of the public or listening, this will be carried to January 9th at the reorg. Same time, 7 p.m. At that time, the new date will be given again, because we do not generally continue public hearings on the reorg. We just do reorg business. And a new date will be given again at that meeting without further notice, other than what's stated on the record, to the new date, which will be sometime end of January or February, most likely, but to be determined.
And if the board needs an extension, do you need it by letter or just on the record?
Well, why don't you put it on the record at least?
All right, so we'll grant an extension through the end of February, gives everybody the opportunity to get it rescheduled.
Okay. Is that it, Marty? We just adjourn?
Well, that's it for the hearing.
Oh, for the hearing.
Closed,
Okay.
and then if there's anything else, I don't know. Yeah.
No, that's it. It just says professional reports and adjournment, so,
Nope, none from us.
okay. Okay, then, thank you, everyone.
Have a great holiday.
Have a good holiday, and we'll see you soon. And if there's none next month, we have any
I
meetings?
don't know, let's get off the record, Courtney, I don't know what they coming up.
Do we have a meeting in December?
2 meetings coming up on the calendar.